6 attorney real estate practice. Illustrative example, not a real firm. The managing partner reviews associate work product every Friday. She catches the errors. She corrects them. She has never written down a single review. 18 months later, opposing counsel challenges a citation in a filed brief. The firm's entire defense is a description of a habit. No file, no log, no policy, no signature. She did the work. She cannot prove she did it. She believed the most expensive sentence in Georgia practice right now. Georgia has no AI rule, so I have no exposure. That belief is the exposure. Hi, if we haven't met, I'm attorney Ford, Juniata's digital avatar. She writes every script I bring you on this channel to ensure you have the human-led oversight and 20-plus years of closing table experience needed to keep your firm ahead of the game. Now think about the closing table. No one ever wrote a rule instructing you to verify the legal description before funding. No bar association issued an opinion titled, "Read the Deed." The duty lived inside competence and diligence, and it lived there long before anyone typed a meets and bounds description into a word processor. You verified because the file demanded it. Let's focus. The myth is simple. No AI rule means no AI exposure. Firms believe it because they confuse an absent rule with an absent duty. The two have nothing to do with each other. Start with the fact. Georgia has not published a formal advisory opinion on generative AI. Committee work is underway. Nothing has issued. What exists is the State Bar of Georgia Generative AI Toolkit, last updated February 20th, 2026. The toolkit says plainly that it is not intended to establish a formal advisory opinion. It is a living document. Most firms read that backward. The toolkit is not a rule. It is the benchmark you are measured against while the rule is being written. Now the enforcement. Shahid versus Isam, Court of Appeals of Georgia, June 2025. The court vacated a trial court order that relied on fictitious cases and imposed a $2,500 penalty, the maximum available under its own rule on frivolous filings. 11 of 15 citations in one brief were fake or unsupported. May 2026, the Supreme Court of Georgia, a 6-month suspension from practice before that court, with reinstatement conditioned on additional continuing legal education. Hear this part precisely. The court stated it has no rule against the responsible use of AI software. It was speaking about its own rules. It then held that citing cases which do not exist or which do not support the proposition asserted violates the court's rules regardless. Enforcement arrived before regulation. 4 Georgia rules govern your AI use today. None of them mention AI. None of them need to. Rule 1.1, Competence. The rule is technology neutral. Using a tool you cannot evaluate is a competence question. Rule 1.6, Confidentiality. Client data entered into an unvetted tool may be stored, processed, or accessed outside the firm. The toolkit instructs attorneys not to input confidential client information into any generative AI solution lacking adequate confidentiality and security protections. Rule 3.3, Candor to the tribunal. What you file is your representation. The drafting source is irrelevant to the duty. Rule 5.3, Supervision of non-lawyer assistance. The toolkit treats an AI tool as non-lawyer assistance subject to attorney supervision. Oversight you cannot prove is oversight you cannot assert. That last one is where firms break. It sounds like this. We review everything. We just do not write it down. That sentence functions as false comfort. Rule 5.3 asks whether reasonable efforts were made. A partner's recollection is testimony. A dated verification log tied to a filing is evidence. A disciplinary body weighs those differently. Compliance measured by intent is not compliance. It is a story told after the fact. 3 steps. No vendor, no budget cycle. 1. Stop waiting. Apply rules 1.1, 1.6, 3.3, and 5.3 to every AI-assisted task in the firm today. 2. Document the supervision you already performed. Capture who reviewed the output, what was verified, and when. 3. Adopt a written acceptable use policy. Approve tools. Prohibited data inputs. Who supervises AI-assisted work? How verification is recorded. It boils down to this. The exposure is not what your firm does. It is what your firm cannot prove. Structure protects people. Risk grows where structure is missing. Find out where you stand. Take the AI Liability Quiz in the description. It tells you whether your practice is a statutory time bomb, a fragile hybrid, or a digital fortress, and what to fix first. For educational purposes only. This is not legal advice. I'm Attorney Ford. Build the foundation. Protect the practice.